Welcome back to the Deep Dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure.
Yep. And today we're diving into Chapter 700, Examination of Applications.
Specifically, Section 708, that's the one titled Order of Examination.
Right. So this isn't about how they examine, but really when. Which application gets picked up next?
Exactly. With so many applications flowing into the USPTO, there has to be a system, right? A queue.
There does.
So our goal here is to unpack that system. What's the standard rule for the order? And maybe more interestingly, what makes an application get looked at sooner? The exceptions.
And before we jump right in, just want to give a quick thank you to Mike Shepard. He organized this whole audio series on the MPEP.
Absolutely. Great resource. And the necessary disclaimer first. This summary, was put together using AI tools.
Right, like ChatGPT and Notebook LM.
So it's for general info educational purposes. It is not legal advice.
Definitely not. Always check the official MPEP itself or, talk to a registered patent practitioner or get formal training.
There could be errors, things missed.
Okay, so the basics. What's the fundamental rule? How does the USPTO usually decide the order?
Well, the default is pretty straightforward, actually. Applications are generally examined in the order they're filed.
First in, first out. Simple as that.
That's the starting principle, yeah. The date your complete application hits, the USPTO sets your initial place in line.
Seems logical, but I imagine if that was the only rule, some really important stuff might get stuck waiting too long.
Exactly. The real world is messy. So, yeah, there are quite a few exceptions to that basic filing order rule.
Okay, so what's a major way an application can sort of jump the queue?
One big category is applications that get designated as special.
Special. Okay. What does that mean in practice?
It means it qualifies for expedited examination. The rules for this are under 37 CFR 1.102, if you want the specifics.
And what makes an application special? Is it about the invention? The inventor?
It could be both, actually. Sometimes it's personal circumstances like the applicant's age or maybe their health. Serious health issues can speed things up.
Okay, that makes sense from a compassion standpoint. What about the invention itself?
Right. That's where policy comes in.
Yeah.
Inventions that materially benefit the environment. That's one.
Ah, green tech. Okay.
Yep. Also things that significantly help with energy conservation.
Also important.
And inventions that contribute to national security, specifically by countering terrorism.
Wow. Okay, so those are some pretty clear priorities baked into the system, accelerating things deemed good for society or national interest.
Definitely. But even outside of those officially special cases, there's nuance within the regular queue, right? How the technology centers manage things.
Yeah, the TCs, the different examining groups, they manage their own dockets. And the source says that even if applications have similar filing dates, they might prioritize based on the oldest claimed domestic benefit date.
Okay, hang on. Domestic benefit date. Can you quickly explain what that is for folks?
Sure, so you file your non-provisional application today, but maybe you filed a related U.S. provisional application a year ago.
Right.
If you properly claim the benefit of that earlier provisional filing date, that earlier date is your benefit date or priority date.
Oh, okay.
So if two applications land in a TC filed on the same day, the examiner might pick up the one that claims priority to an earlier U.S. filing first, because its effective invention date is older.
Got it. So filing day sets the main queue, but benefit date can shuffle things within that queue at the TC level.
Exactly. A subtle but important distinction.
Okay, so we have the basic filing order, then we have special cases getting expedited, and some TC shuffling based on benefit dates. What about the absolute top priorities, the VIP lane?
Right. Some things go straight to the front. The highest priority seems to be for litigation-related cases.
Litigation, like reissues or reexaminations tied to a court case.
Precisely. If a patent is being fought over in court, and a related reissue or reexamination gets filed at the USPTO.
Why does that get top billing?
Well, think about it. There's an active court case potentially waiting on the USPTO's decision about the patent's validity or scope.
Ah, so the court needs that information.
Exactly. The USPTO prioritizes these to help the judicial process move forward. They can't just let a court case hang for years waiting on them.
Makes perfect sense. What else is in that highest priority tier?
Things with fixed deadlines. The main example given is an examiner's answer to an appeal brief.
Right, when an applicant appeals a rejection to the PTT, the Patent Trial and Appeal Board.
The examiner has a specific time frame to write their response to that appeal. That deadline is firm, so preparing that answer becomes a top priority task.
Okay, so legal pressures and hard deadlines push things way up. Are there other, maybe slightly less urgent, but still prioritized categories?
Yes. The system also seems to prioritize based on where an application is in the examination pipeline. It's about workflow, really.
Likewise,
Well, applications that the examiner thinks are basically ready for allowance.
eating ready to become a patent.
Yeah. Or, conversely, ready for a final rejection. Those often get moved forward.
Sort of clearing the decks, getting things to a conclusion.
Seems like it. Get it off the pending list. Another category mentioned involves applications in interferences.
Interferences, to figure out who invented first? I thought that wasn't really a thing anymore with first to file.
Well, yes and no. It mainly applies to older applications, the ones filed before the American Invents Act kicked in back in 2012.
Ah, the pre-AIA cases.
Right. Under the old first to invent system, you needed interferences to sort out priority. Those older cases are still governed by the old rules, so resolving any remaining interferences is still a priority to clear out those legacy disputes.
Okay, that makes sense for those older applications. Any other priority bumps?
One more interesting one, reflecting perhaps the reality of backlogs, applications that have been pending for more than 5 years.
5 years. Wow, so they try to push those older ones through too.
Seems to be the idea. Don't let things linger indefinitely.
The examples provided really help illustrate this. Let's talk about the first one. The reissue application under litigation stay versus a regular continuation in part.
Yeah, this is a great illustration. Say you file a standard continuation in part application. In the same week, someone else files a reissue application, but that reissue is tied to an ongoing lawsuit. Maybe the lawsuit is even paused, waiting for the reissue.
Okay.
Even though they were filed around the same time, that reissue application is going straight to the high priority queue because of the litigation connection. It'll get examined before the continuation in part.
The lawsuit factor completely overrides the filing date order in that case.
Totally. What about the second example, the Track 1 program?
Track 1. This is different because it's something you, the applicant, can choose to do.
Right. It's an expedited examination program. You pay an extra fee.
And you have to meet certain requirements, right? Like claim limit.
Exactly. Strict limits on the number of claims, usually. If you meet the criteria and pay the fee, your application gets put on, well, the fast track, Track 1.
So you can essentially buy your way to the front of the line if speed is crucial and you can meet the conditions.
Pretty much. It's a way to get a final decision much, much faster than the normal waiting time. It's an applicant-driven priority path.
So that's another way an application becomes special. But through the applicant's proactive choice and payment, not just based on the tech or situation.
Correct.
The source also mentions some procedural stuff related to this order of examination. Things like handling amendments, case transfers.
Yes, the operational gears. How do you handle an amendment that comes in, especially after a final rejection that affects the timeline? How do you manage transferring a case between different technology centers without it falling into a black hole?
Right, that transfer needs to be smooth. And correcting benefit claims.
Super important, as we said. Getting that priority date right affects your place in the TCQ. Mistakes there can cause delays while things get sorted out.
And printer rush notices. That sounds a bit old-fashioned.
It kind of is an older term, but the concept is still relevant. Think of it as any task with a really tight, often publication-related deadline, like getting an application ready for its 18-month publication. Those tasks have to jump the queue to meet those external deadlines.
Okay. And a key point seems to be that once a case gets this special or prioritized status, it keeps it.
That's what the material emphasizes. If your case is made special, it stays special throughout prosecution. It doesn't just get one quick look and then go back to the end of the regular line. It stays prioritized.
So let's bring this back to you listening. Why should you care about MPP 708 and all these ordering rules?
Oh, it's fundamental if you're navigating the patent system.
Right.
It directly impacts how long you might wait for examination.
Right. Knowing the rules could potentially speed things up for you.
Definitely. If your invention fits one of those special categories, environment, energy, health, knowing how to request that status could shave years off your timeline. Or if speed is critical, knowing about Track 1 gives you a strategic option.
It helps set expectations, too.
Absolutely. Understanding where your application likely sits in the various queues helps you plan better and understand the potential timelines involved. It tells you what levers you might be able to pull.
So it's clearly not just about when you file. It's about understanding this whole complex system of queues and priorities.
Exactly right. Knowing the landscape helps you navigate it.
Okay, that was a great deep dive. We've covered the default filing order, but really spent time on the exceptions, the ways applications get special status.
Yeah, due to applicant age or health, the type of technology like environmental or energy tech.
Or specific programs like Track 1, or procedural needs like litigation or appeal deadlines.
And even just clearing out old cases or ones ready for decision. Lots of factors.
It does leave you with something to think about, doesn't it? How does the USPTO balance all these competing demands?
That's the provocative thought, I think. You've got individual needs, like an elderly inventor. You've got broad policy goals promoting green tech. You've got legal system demands from litigation. And you've got the simple administrative need to manage a massive workload efficiently. How do they weigh all that?
It's definitely a complex balancing act. Something to mull over. Okay, just one final time. Remember, this was an AI-assisted summary meant for education. It's not legal advice.
Please consult the official MPEP or talk to a qualified instructor or registered patent practitioner for any authoritative guidance.
Thanks for joining us on the deep dive.